Get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And before we get to questions, David, I have disparaged your character. Any response?
Well, I just like a list of the ones
you got wrong.
A list of the ones that are wrong. Right? How many pages is it running to?
I don't have any. There's none.
Okay.
Right, every time.
Okay.
That's what you get when you
My
ring.
lawyers will be talking to your lawyers. Yep.
That's one of the most terrifying lines. I just wanted this on the record. I never want David Wyden to ring me and say, my lawyers will be talking to your lawyers. That is something I never want to happen. But let's go straight to Felicity, who's calling from Hobart. Felicity, what is your question?
Oh, hi. We recently went on holiday and unfortunately our car broke down and we needed to be towed. Because we were on holiday, we had our 3 bikes attached to the back of our car. So we rang our roadside assist and they said, yep, that's no problem. We'll be able to take the bikes and the car. The tow truck driver turned up and said the same thing, there's no problem. But from taking our bikes and our car to a different location, he dropped our bikes and they all got crushed and also damaged the back of our car. And it's been a 3-month investigation now, and they've just turned around and said, no, it was our fault because we had the bikes on the back of the car. But
presumably they were on the back of the car when the tow truck driver turned up.
Yes, but we did say, is that okay? We would have happily taken them off and come back for our bikes later. Like, if it was an issue at all,
Felicity, you have a claim under the Australian consumer law, which will apply. I know you're ringing from Hobart, so I'm making some assumptions about the law in Tasmania. I would fully expect that Australian consumer law would apply nationally.
So is that... Yep. Sorry, is that the CBOS? Is that because I've been through different, like I've been to AFCA and CBOS, and they've both told me there's nothing that they can technically do about it.
I think you have a civil and administrative tribunal in Tasmania.
Yeah.
You do. That's where you would take an Australian consumer law dispute. Right?
Okay.
And your action would be against both the insurer who you called to provide a towee and also against the towee for the work that was done. Now, the towee will be an independent contractor and not employed, but I can also tell you that the service organisation that you rang to call a towee will have a recording of your call. All right?
Yeah.
So all of that's available to you. That's the process that you would follow.
Okay. Sure. And if they just literally say that's your fault, there's nothing we do.
No. This is a question where in the performance of their obligation, they have damaged something. So it's a question of who gets, first of all, the question is who's responsible. I'm saying that the tow truck driver agreed that there would be no damage. And if he has failed to inspect properly when putting everything on the back of the truck, I understand that the bikes might fall, but you use the word crushed. And crushed means to me more than they fell off the back of a truck. So I would be taking up that process. Just ring the tribunal and make sure that they do Australian consumer law complaints, and it's Tasmania.
Okay?
Okay. Yeah, thank you.
Good luck, Felicity. Harry's calling from Moorabbin. Harry, what's your question?
Yes, good morning to both of you. My business partner and I have a little factory in Moorabbin, and there's about 40 in the complex, and they're all the same size. Our problem is 10 of the owners haven't paid their body corporate fees, and one of them hasn't paid for 10 years, and he owes $11,000.
You have a remarkably tolerant owners corporation manager, Harry.
Well, he's not doing the right job, David. And the management company now has increased the body corporate fees by 30%. And we reckon...
Oh, that's so that you can fund the owners corporation without the others paying.
That's what we reckon. And he says, no, it isn't. He said, you haven't had a rise for some years, and this is because your insurance is going up.
Yes.
So we don't know what to do.
And my
I'm
guess
sorry,
is you could hold a meeting for the purpose of replacing the manager.
Yes.
So you would call a meeting and say, this manager isn't doing the manager's job properly. I want you to do something about it.
Yes.
Now, my thoughts are if you've got 10 people who are delinquent, they're not going to be really keen voting in favour of that resolution, I would not have thought. But there are limits to the resolutions that you can vote on if you're in default. So start with that one.
But
right.
Can I jump in there? But you're not allowed to vote if you're not financial,
Yeah,
are you?
so there you go. So everybody's voting in favour is you. Now, in the event that for any reason that fails, then you could make an application to VCAT to say an administrator needs to be appointed to the owners' corporation because we're being ganged up on by the other unit holders and the owners' corporation manager such that it isn't being run properly.
Okay.
All right. So I would be going to the owners' corporation manager and saying, what steps are you taking to collect arrears of fees and why are you not collecting arrears of fees?
Okay, Harry.
Right. Thank you, Harry.
Good luck.
Okay, thanks so very much.
Thank you.
Good luck, Harry. And just a quick sub-question, David. Do you have an opinion on how likely they are to get back 10 years worth of fees?
Under the Subdivision Act and the Owners Corporation Act, they are a charge on land. The unpaid fees are a charge on land, so the property will not be transferred. So you'll get it. Can you get back 10 years of fees? Yes, you can. Right?
Technically.
Well, no, it's a charge on land. It takes priority to the mortgage. It takes priority.
Right.
So the property will ultimately be sold, and you stick your hand up and say, I want the money. And if the owners' corporation rules provide for the payment of interest in the event of a default, then you pick up your interest at the same time.
There you go. Good luck, Harry. Jane is calling from Coburg. Jane, what's your question?
Hi, Raf. Hi, David. I'm going to try and keep the language as neutral as I can. A person close to me has or had some shares in joint name in the joint direct shares account with their sibling.
Yep.
The shares were sold over 2 taxable years.
Yes.
For a total of approximately $150,000.
Yep.
The tax implications of around $30,000 have been charged to the person that I know in their tax return.
Yep.
2 things. Can the sale of the shares amount be retrieved, and or can the tax implication be retrieved from the sibling?
So what happened to the proceeds of sale of the shares?
They all went to the sibling. The person that I know hasn't seen any of the proceeds of the shares sales.
Okay. I would be talking, presumably they were sold through a broker?
I assume it was sold through the app that they can both access the shares through.
Yep.
And it's also been requested to have the money returned either both.
No, hang on. My guess is that the arrangements that you've made with the broker by allowing both people to have access is such that they are able to execute a trade, sell the shares, transfer the shares on the basis of instructions from one of them.
Correct.
Right? Now, if that's the case, there is no issue between you and the broker. The next question, though, is as between and where did the dividends go when the shares were held? Did they go into a joint account?
Yes, I assume they've been invested back into the account.
I say you're in no. Then you're in a dividend reinvestment program and nobody ever saw any cash. Is that right?
I assume.
Radio. Okay. Yeah. Then when the shares were realised, they will have gone into an account that had been agreed between the share owners and the broker. And what's happened is the other party has simply snaffled the money.
Correct.
So
correct.
on that basis, as between you and the tax or your colleague in the tax office, there's the tax is owed by the person who didn't get the share proceeds or any part of it. He has an action against his sibling to recover. Can't recover the tax because he'd authorised the share sale, but certainly his share of the proceeds of sale.
Yes.
Right
So
now,
how-
whether he chooses to do that or not, it's a different question.
How and where would you
Well,
do
you
that?
would. It's going to be depending on the value. On the numbers that Jane has given us, it's a magistrates court claim. It's not a VCAT claim.
Okay.
And your claim is to sue the person who's directed the sale and snaffled the dough for half of the money received.
Yep. And in terms of I know you can't tell me exactly, but in terms of the money that it would take and the effort that it would take to do that versus let's go $75,000, $80,000 worth of the share proceeds.
Yep, worthwhile. Well, I don't know what the snaffler has in terms of resources from which this claim might be satisfied. But my view would be I wouldn't let $80,000 walk out of my life without trying to do something to recover it.
Okay, Jane.
Thank you. Appreciate it.
Thank
Good
you.
luck. So Magistrates Court is your first port of call. David Whiting answering your legal questions. We had Jane in Coburg just before. Now we've got Frank in Coburg, coincidentally. Frank, what's your question?
Hi, Ralph, David. Body corporate question. The body corporate we're with, they haven't invoiced us or billed us for 3 years. And so we got an invoice for 3 years' worth with the usual, pay it, and if you're late, you get, extra percentage of fees on top of. So a couple of questions, and this is the second time they've done this. Happened about 5 years ago, similar scenario. Question is, are we obliged to pay it all off at once? Can we, I suppose, negotiate or try and pay it in instalments? And the other question is, when it happened about 5 years ago, I asked them for insurance documents. I just want to make sure they're paying insurance, building insurance, because if they're not collecting fees, then what are they doing? And they never provided that. So am I obliged? Are they obliged to provide documentation on what they're using these fees for?
Yes, they are, and they provide them in financial statements that are presented to the annual general meeting. But let's deal with the first question first, right? It would appear to me that you've got an owners corporation manager who does not bill annually, but bills every 3. I mean, let's pluck a figure from nowhere. Let's say typical owners corporation fees would be $1,000 a year. There's no logical reason why they couldn't hit you with a bill for $3,000 every 3 years. Right now, they set annual fees. So you would need to look very closely at the minutes and the resolutions to find out what your liability is and how it arises. But if they were to come along and say, I need $3,000 this year, A, to restore reserves, B, to meet ongoing expenses, then I would see that as erratic billing, not I've now billed for 2 years ago, I want you to pay, and I billed for 1 year ago and I want you to pay, and I'm billing for this year and I want you to pay.
So erratic but legal?
Erratic but legal. In terms of the second one, again, it should be in the financial statements produced every year as to what they're paying for the insurance.
David, sorry to interrupt. This is the other thing. I've been here 14, 15 years, and we had one meeting in my first year here. And there's been no meetings and no minutes.
How many
no
units in the
financial
block,
statements.
Frank?
Sorry.
How many
3.
units?
3.
Only 3. And you've got a professional owners corporation manager, or is it the person in one of the units?
It's a real estate company, and the manager works for the company, for them. So
But not the individual. It's the real estate company is the manager, and the work is assigned to an individual. Is that right?
That's right, yes.
Then why would you not have the discussion with the principal of the manager, rather the person who owns, in fact, the technical title is Officer in Effective Control of the estate agency. Turn around and say, I've got a problem. So why would you not have it at that level rather than the person who does the paper processing for you?
We have, and they are very hard to get hold of, and they protect the worker, and you can make
No, except
20
all of
calls.
those things. So what do they say? Or do they just not talk to you?
They just brush it off. They don't say anything. I've complained.
Brushing
about
off and saying nothing are not the same,
No,
Frank.
I've complained that why we should be having meetings every year. We should be like each of the units have
Well,
had
then
it.
why not talk to the other 2 and fire them?
Well, we can. Oh, that was my next question. Can we, as a group, stay our own body corporate, or does it have to be something?
No, you can run it yourself. I think you're slightly mad. Most people have difficulties running it themselves, but it is technically possible. I think the Victorian Law Reform Commission at one stage had a guide to owners corporation management. So what I want you to do is look and see if you can find that resource or something like it. Decide whether the three of you want to manage it. Now, what often happens is that there is a contract for the engagement of an owners corporation manager. I would have said you currently don't have one because you haven't had a meeting. And my other question, of course, is if you haven't had a meeting, how can you set the fees? Right, because it's the owners corporation that sets the fees. It's not a random figure picked by the owners corporation manager. Good luck.
Frank, good luck. So try that resource. That was Law Reform Commission, David?
Victorian Law Reform.
Victorian Law Reform Commission, and more of a conversation perhaps with the
It's a bit old. I think it's called the body corporate rather than owners corps. But, you can Google amazing things.
Sally is calling from Hampton. Sally, what's your question?
Oh, hello. So my question is in regards to a will. Two parents that died, say, 4 years ago, a year apart from each other. There are three siblings, one of whom is the executor. I am one sibling, and we have another sibling.
But you're not the executor, are you, Sally?
I am not the executor.
Okay,
no.
yep.
The trouble that my other sibling, who is the executor, is facing is that the other sibling won't provide any financial account, like a bank account, for their share of the will or the gift from the will.
Oh, this is so easy, Sally. You send it to the State Revenue Office as the collector of unclaimed monies.
Right.
Mm.
So they've been difficult, and they've
Sorry?
Yep, sorry. So they've had some, I don't know if it's a formal contesting of the will, but there's been discussions and they've had a lawyer involved, and there's been, in fact, a couple of lawyers involved, but they never seem to stay. I think
so this is from we'll call this the recalcitrant sibling has made a claim against the estate to say, I'm not satisfied with what I've been provided with.
Correct.
And but so my question would be, if all of those issues are resolved, and I mean resolved in a legal sense, not resolved in an emotional sense.
They are T's crossed, I's dotted.
Then the answer,
and
so he's entitled to, I know, let's call it $5. Refuses to take the $5 or tell you where it can be paid. The solicitor probably won't take it on his behalf. The process is it's the Unclaimed Monies Act, and the money goes to the collector of unclaimed monies.
At the SRO.
At the State Revenue Office. Right?
And then would that just sit there and...
Well, the government will enjoy using it for as long as it possibly can. and it will be possible... It will be possible for the recalcitrant sibling to claim it. Okay, but it will enable the other sibling, who's the executor, to wrap up the administration of the estate and put away the file.
Okay.
Excellent. Thank you so much.
Thank you.
Good luck, Sally. Tim is calling from Garfield. Tim, what's your question?
Oh, yeah, g'day. We bought a house in Garfield, and it turned out to be like a health trap with significant toxic mould. We have had it tested, and it did come back with toxic mould. And we found the visible mould 2 days before settlement. And we went to our settlement lawyers and told them about this. And they told us that the only thing we could do is back out of the contract and lose all our deposit, which obviously we couldn't afford to do at the time. We've since consulted other lawyers, and they've told us that we do indeed have a case against the lawyer and possibly the guy that did the inspection on the house. But it would cost us $90,000 plus, and we would be up for all the fees if we lost.
Tim, let's look at the various claims. Your claim against the person who inspected the property on your behalf is probably going to fail because under the standard conditions you get a building inspection to look for major structural defects. And you get a pest inspection
Yeah, we did, yep.
Yeah, but you get that for significant pest infestations. So a mould is neither of those.
Yeah,
So
right.
it will
We
not
did
have
ask
been.
him- We did ask him because we've had previous health issues with mould in our previous home, and that was actually why we moved. And said to him, "Can you please look for mould?" And
Well, your
I don't
next
know.
proposition, Tim, is that these inspections normally happen within 14 days of the date of sale. My expectation is that the vendors would have made an extraordinary effort to get rid of all evidence of mould prior to the date of sale.
Yeah.
So I would be suggesting you may have more information, but and I don't see that you've got a claim against the vendor, but you might if you can argue that it was a fraudulent claim. But yeah, the only place you can take those is to the magistrate's court, and I would have said that if you had delivered the property, the vendor has an obligation to deliver the property to you in the same condition as it was when you inspected. And I would have thought significant mould would not be in the same condition. So you would at least, or should have had the option of saying, contract's over, I want my money back because there's mould that didn't exist at the time you offered the property to me.
But magistrate's court.
And it's a magistrate's court claim.
So it was there. So it was a couple of days before settlement. So
I know, that's not the date of sale, that's the date of settlement. So if you're bought on a 90-day contract, there could have been significant mould developed within the property in the 90 days. Now, the only other thing that you need to think about, Greg, Tim, is what's the cost of fixing the problem? And it may well be the most efficient outcome and use of your money and your time will be to invest in fixing the problem, not walking away from the property. But I don't have the answer to that one.
Good luck, Tim. That does not sound like a simple proposition at all. David, do you have... No, you don't have homework.
No, I want to have a look at Harry's Owners Corporation question.
By the way, yes. Just a note on self-managing. Rob has this for you in McLeod. Self-managing Owners Corps. I've managed our 5-lot subdivision for 5 years. There's nothing difficult about it. We get more done than ever under commercial management. I encourage all small Owners Corps to seriously consider self-management.
Okay. Is Rob offering his services? I don't know. Anyway, look, some of them do it really, really well.
Yep.
Quite a few of them don't.
Okay. Thank you, David.
Thank you.
David Whiting taking your legal talk back every Tuesday after the 10 o'clock news. The way it works, if he doesn't have an answer off the top of his head, we give it to him as homework, or he claims it as homework, and he'll deliver the news the following week straight after the 10 o'clock news.